Welcome to Crime in Court. My name is Heather, and this is an update in the Canton cover up series Commonwealth versus Karen Reed and Aiden Turtle Boy Carney. Today we're going to be talking about Turtle Boy and reading through the Bederow Letters, Part 3 Corruption Exposed. So, this is the third installment hand looks like I didn't have all my fingers there. Um, this is the third installment of the Mark Butterow letters from the attorney, none other than the great Mark Butterow from YouTube. Well, no, he's an attorney, but he has become almost, famous in his own right just for commenting on the Karen Reed case with other YouTube creators. So he is an attorney in New York, and he was brought on to the Turtle Boy case. So Turtle Boy already had an attorney who is Tim Bradel. He's a big First Amendments guy, so he's great for like civil rights and First Amendments and things like that. Well, Bederow, I don't know, he just has this really good way of like wording things, and his books I mean, his letters should like be turned into a book one day. All of his legal writings, I think he's got some great things to say. And he just says it so eloquently and saying the things that we want, like we're all thinking, but we don't know how to put it into words. But before we get to the Bederow letters, we did an update. It was a breaking news stream where I talked about the fact that there might be some changes well, there are some changes going on in Norfolk County. So one, David Traub, the PR communications guy, up and resigned. They got a new guy who basically is like another arm of law enforcement. He's only going to be, he'll be doing the bidding of Michael Morrissey, most likely, based on his past experience. So there's that. Who else left? Lynn Beeland, who is like the second in command, the second in charge at the Norfolk County District Attorney's Office. So she up and retired. And what else? We're missing. I know I'm missing some other people. Oh, Tully just recently was reassigned. So I did. Oh, and we also know that Michael Morrissey and Ken Mello now have they have instances on their record of misconduct and bias and things like that. So we went through all of that in different videos. So I just wanted to recap that. Well, also in the last breaking news video, I discussed the Howie Carr post that I'm going to read to you right now. So on was it Saturday, October 20th, I think that was Saturday, Sunday, whatever day it was. Um, Howie Carr, who is a local news radio guy, he has a column in the Boston Herald. He put this post out on his X page. He said, breaking, more bad news for Meatball Morrissey's attempts to frame Karen Reed. Hearing from reliable sources that Judge Cannone, or as many of us know her, Auntie Bev Cannone, is out as of January 1st as the boss of Norfolk Superior Court. Her current title is Regional Administrative Justice. I'm going to pronounce it as Raj, as in the old days of British colonial rule in India. So she's like the boss of all the judges in the Norfolk County area right now. Not sure if Raj is like being president of the Elks Club for a year or so, and then you get rotated out automatically. But judicial sources tell me that when the Raj is replaced, as Cannone is about to be, he or she generally moves out of the rotation of the county that they are the boss of, in this case, the rotten borough of Norfolk. Often, the deposed Rajas flee their previous base, so they would leave their position to go to their Cape mansions up until they reach mandatory retirement age. So I guess that's when you're booted off at 70. Doesn't Auntie Bev have a mansion in Centerville? Howie Carr asks. And we believe that she does have a cottage or something somewhere because Scott McCabe made a comment to Turtle Boy that that's where they're going to bury his body was Auntie Bev's Cape Side or yeah, Cape Side cottage or something like that. I can't remember the exact terms, um but she denied that she even knows any of them. So, you know, no big deal. Even though I think the McCabes have a house near them. That's what I've heard. I don't know if that's actually confirmed, but I think the McCabes have a Cape house near Auntie Bev's Cape house. If Canoni's out of Norfolk County courtrooms, and I don't know for sure that she is, and it's unlikely to be officially announced anytime soon to avoid further humiliation for the reeling meatball mob. The meatball mob. Any judge would be an improvement if indeed Morrissey's second attempted necktie party for Karen Reed takes place in Dedham in January. As you know, the fix was always in with Cannone presiding. Remember her jury verdict forms with no options for a not guilty finding? Cannone is a second generation hack layout. Her father was a courthouse payroll patriot in Quincy, Meatball's hometown. At 63, she has never worked a day in the dreaded private sector. Her hack brother was the public defender for jailbird Chris Albert, the Canton selectman, piss poor pizza purveyor, and brother of dodgy cops Brian and Kevin Fat Albert. In 94, jailbird Chris was convicted of taking the life of a guy in a hit and run car accident and did 6 months in the House of Corrections. Yeah, he hit some guy and then he drove away. He drove home, but his car was leaking gasoline or oil or something, and they followed the trail and found him. In other words, Cannone is Norfolk County hack royalty. Of course, she refused to accept the not guilty verdicts from the jury in Karen Reed's first kangaroo court trial. I just hope that being stripped of the Raj title means Auntie Bev is gone, period, from Norfolk County. It would be good for justice, bad news for Just Us Corporation that has destroyed all confidence in law enforcement under Meatball Morrissey. This has not been a good weekend for Meatball. The only upside, as I mentioned in my Herald column, is that the Pats game in London started early. Yeah, so this was Sunday. So it's kind of like Thanksgiving morning, and you get to have booze on your breath before noon, like before the traditional high school games, and everybody pretends not to notice. Right, Meatball? Pour yourself another Captain and Cola in memory of Auntie Bev, framingest judge south of Neponset. So I thought it was an early Christmas for all of us, but I have disappointing news. Judge Bev is not out. So Howie Carr got our hopes up too soon, too soon. So he reached out to uh, Superior Court and got a response. So here is what happened. So the next day, the following day after Sunday, so Monday, the following day, he posted this. Breaking, Judge Auntie Bev Cannone will remain as judge in second trial for Karen Reed in the Superior Court announced that this morning, so yesterday morning. Um, now confirmed that she is out. Wait, what? Now confirmed that she is out as Raj, Regional Administrative Justice of Norfolk County as of January 1st, but trial court claims that that's merely a rotation. So she is out as the Raj, the regional. She's no longer going to be the boss of all the judges of Norfolk County anymore. She doesn't get to schedule everything and, be in charge as much. So, but she's still going to be on the Karen Reed case, unfortunately. A funny coincidence, I guess you could say. Blacks also claim that after she catastrophically ran the first kangaroo court trial of Reed, Auntie Bev will remain in the Just Us system of Norfolk County. That's where she grew up as a second generation payroll patriot in the Quincy Hackorama. Here is the statement below from Superior Court. It reads, Hi, Howie. In Superior Court, regional administrative justices and other leaders serve in their leadership roles for 3 years, after which they rotate out of them, barring exceptional circumstances. For that reason, several administrative justices and other leaders will, in 2025, rotate out of those roles, including Judge Cannone, from her role as Regional Administrative Justice in the Norfolk County. Judge Cannone will continue to serve in Norfolk County in 2025 and will preside over the Commonwealth versus Karen Reed case in January. Wah, wah, wah. My heart broke when I read that because I hate Judge Cannone so much with a passion, but there's still time. There's still time for them to make a decision where Judge Cannone is no longer going to be presiding over it. So I'm going to keep my hopes up and hope that they're just giving us the runaround to say, oh, no, 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 nothing's changing. She's just rotating out of her position. But maybe, just maybe, there might be other things going on that we don't know. Anyways, so for that reason, several administrative justices will be rotated out. Judge Cannone will continue to serve in Norfolk County in 2025 and will preside over Karen Reed. She will also assume the chair of the Superior Court's Criminal Committee. So now she's going to be the chair of some criminal committee. Great. We need her in criminal court. We need her dealing with that. And that was signed Best Jennifer. So basically, and then Turtle Boy makes a point here. He's like, so what am I missing? They say in one sentence that the justices, including Cannone, are being rotated out of their current courts. And then in the next sentence, it's saying that she's not being rotated out. But I think he's confusing. I think she's staying in Norfolk. She's continuing to remain as a judge in Norfolk. She's just no longer going to be the Raj in Norfolk County or of Norfolk County, whatever. So that is a big bummer, in my opinion, to bring to you. But sorry, I had to report the news. It's true. So she's back as of now. And there is a motion hearing coming up, and I'm not sure what the motion is, but somebody got a motion hearing on the record coming up in November, I believe, 13th or something like that. So we'll definitely report on that when it happens. So next, I want to get to the Bederow letters. This is why we're here. Okay, so we're going to go through the Turtle Boy blog where he explains all of this. First up, we're going to read the letters, and then he goes through like all the discovery that is mentioned in the letters and help bring it all together to make sense for us. Okay. So this is Canton Cover Up Part 423. Michael Morrissey used burner email account to investigate Stoughton court whistleblower. Lied about going through Turtle Boy's phone and told judges to make certain orders. So we got Mello here and Morrissey here, both of them now under, I don't know if they're under any kind of investigation, but they have misconduct uh, under their names, on their records, under their licenses to practice law. So, all right, so let's start out with Turtle Boy's introduction. He says, Attorney Mark Bederow has entered Part 3 of Bederow letters into the official court docket, and it's the most explosive and damning exposure of corruption thus far. These letters are written to special prosecutors Robert Cosgrove and Ken Mello and will be used as a basis for motions that will be argued in court at upcoming hearing dates. while the first two installments detailed damning allegations of a setup to frame Turtle Boy by Kate Peter, the fake victim, that's Lindsay Gattani, Ken Mello, Nicholas Guarino, the data extractionist who can't seem to find exculpatory data, and Brian Tully, that were discovered in the fake victim's phone extraction. Oh, what damning allegations of a setup to frame Turtle Boy by all of these people: Kate Peter, fake victim, Mello, Nicholas Guarino, and Brian Tully. I want to know more about this Nicholas Guarino's part in this because it's mentioned here that he is part of the topic, but we don't really hear about him much in this. So I'm hoping that some more comes out about that. I would love to hear if Turtle Boy talks some more about how he knows Nicholas Guarino was part of this. All right, so it involves Morrissey using a private email account to conduct secret ex parte communications with judges in my case that Morrissey didn't want me to know about, provable lies perpetrated on the court, withholding of critical evidence used to try to indict Karen Reed and Turtle Boy, glaring conflicts of interest, surveillance of my children, watching his kids, and state police using extracted messages from my cell phone that they used to fire a whistleblower who broke no laws. And he didn't even know. So let's get started. I'm going to switch over here to the Bederow letters. And it is addressed to Special Assistant District Attorney Robert Cosgrove. And Mello's not even on here. So I wonder if you forgot to put Mello's name underneath or what, but usually you add, no, he had been adding Mello up to the top. Mello is MIA. Robert Cosgrove is the attorney that is filling in for Mello while Mello is MIA. He's saying medical issues, so we'll see. It all happened right after the evidence of Mello setting him up came out. So I don't know if it's related or what. All right, so dear Cosgrove, we are scheduled to appear in the Norfolk County Superior Court on December 2nd, 2024 to address issues related to the Commonwealth's search of Aidan Carney's cellular phones. To date, the defense has not been provided with any data or extraction reports from Mr. Carney's devices, which have remained in the Commonwealth's possession since the Massachusetts State Police seized them on October 11th, 2023. We are now 300 and what, 75 days out from when they took his phone, his cell phone, his computer, all of his devices, everything that he uses to report on stories, all of his sources, everything. They took everything and haven't given it back. It's been over a year. For approximately 1 year, the Commonwealth has claimed or implied that Mr. Carney's cellular phones have not been searched. These representations are patently false. I want to say if you ever have to get arrested for some reason and the cops are taking your phone, do not share your password with them. Make it difficult. I don't care what is happening. Don't hand it over. Don't give it to them willingly. And don't give them your password. Just saying. Just a warning. Because of things like this. So they've said that the cell phones have not been searched. Okay? These representations are patently false. Norfolk County District Attorney Michael Morrissey and Special Assistant District Attorney Kenneth Mello have known since October 2023 that MSP Detective Lieutenant Brian Tully searched Mr. Carney's cellular phones and that the MSP extracted at least one of them prior to October 31st. So within 20 days of receiving them, they already extracted it. We recently came into possession of several pages from a Cellbrite extraction report of Mr. Carney's cellular phone. The Cellbrite report identifies the quote unquote owner of the extracted Apple device as Clarence Woods Emerson, which is a pseudonym that is used by Mr. Carney on Facebook. And this is proof that it was searched by Detective Lieutenant Tully on October 2023 during an investigation orchestrated by DA Morrissey into alleged witness intimidation of Chris Albert and Jennifer McKay by a Stoughton court clerk and Mr. Carney. It is outrageous that the defense obtained evidence in your actual possession related to alleged intimidation of named witnesses in the indictments against Mr. Carney from a third party rather than from the Commonwealth, who is obligated to disclose this evidence to the defense several months ago, but instead has repeatedly denied its existence. On the record to judges, they lied. DA Morrissey launched the investigation, which relied upon the MSP's search of Mr. Carney's cellular phones on September 29, 2023. This was after he engaged Mr. Mello to handle any investigations involving Mr. Carney due to a conflict that arose after Mr. Carney's dogged reporting exposed information that persuaded a large segment of the public that the Norfolk County DA's office and MSP framed Karen Reed for the homicide of John O'Keefe, which almost overnight created the worldwide Karen Reed movement. And that is what I'm talking about when I say his letters and his court filings should be turned into a freaking book. He has a way with words. So, despite similar, if not worse, conflicts with Mr. Carney, the Norfolk County MSP Homicide Unit has not recused itself. Detective Lieutenant Tully is leading an investigation in which his two direct subordinates, Trooper Michael Proctor and Sergeant Uri Buchanan, are alleged victims of Mr. Carney. DL Tully and Trooper Proctor are presently under MSP internal affairs investigation, and Sergeant Buchanan already has been disciplined. He lost 5 vacation days. Big freaking whoop. For their inappropriate conduct in the Reed case, which bolsters the credibility of Mr. Carney's reporting on the case. Yes, it does. All the um, internal affairs investigations, all of the punishments, the discipline that they're getting, it just gives Turtle Boy more credibility to everything that he's been reporting from day one. He's been consistent. He has been saying the criminals in this case that we need to look at are the ones that are investigating the case and investigating people reporting on the case, which is just blatantly obvious that they have a reason to do that. This obvious conflict, combined with the Norfolk County MSP Homicide Unit's exploitation of the Massachusetts witness intimidation statute by utilizing it in favor of witnesses who despise Mr. Carney and refusing to employ it against those who are aligned with Mr. Carney and or are critical of the Reed case, exposes the unit's animus towards Mr. Reed and creates the appearance of an improper motive for investigating him. So they're using this bogus witness intimidation statute, they're weaponizing it against him, basically to silence him, and yet there are people on the Karen Reed is guilty side that are way more guilty, I guess, of witness intimidation, and they aren't being charged. So why is it there's a discrepancy as to who, you're picking and choosing who you make follow this law. So it's a good point brought out by Bederow. As DA Morrissey recognized in recusing his office, public confidence in the MSP and the Norfolk County criminal justice system, which currently is dreadful in large part due to the MSP Norfolk County Homicide Unit's conduct in Mr. Carney's cases, the Reed case, including Trooper Proctor's suspension without pay for his shocking and disgraceful treatment of Miss Reed, and the flawed Sandra Birchmore investigation compels that the Norfolk MSP homicide unit be replaced with unbiased investigators from another county. Damn, say it, Mark Bederow. Tell him, get out of here, because you guys need to be just totally revamped from top to bottom. I love it. I love snark in legal documents, and it makes me happy. All right, so lest there be any doubt that Mr. Mello didn't know in October 2023 that Mr. Carney's phones were searched and at least one extracted, his failed attempt to indict Karen Reed and Mr. Carney for conspiracy to commit witness intimidation shortly before Ms. Reed's trial, in which Mr. Mello elicited testimony from Detective Lieutenant Tully that he searched Mr. Carney's cellular phones in October 2023 settles that question. There is actual grand jury testimony of Lieutenant Tully being asked by, was it by Mello? Yeah, Mello elicited testimony from Tully, and Tully admitted that he searched Mr. Carney's phone in October of 2023. So, on record, court transcript, can't deny it. Tully admitted it, yet they are being told over and over and over again from Mello and Cosgrove that these devices have never been searched, but it is admitted on the record here by Tully. We are deeply troubled by Mr. Mello's misleading representations, which have left the court and defense with the false impression that Mr. Carney's devices have not been searched. To be clear, we do not believe that Mr. Cosgrove has deliberately made inaccurate representations to the court and or defense. Rather, it appears that DA Morrissey, Mr. Mello, and DL Tully have failed to inform him about the true consequences surrounding the searches and extraction of Mr. Carney's cellular phone. So they're like, just to be clear, Mr. Cosgrove, we don't think you're lying to us. We think Mello and Tully all lied to you and are playing you like a fiddle, and you're buying it. Put simply, it is undeniable that the Commonwealth has failed to disclose any evidence from Mr. Carney's devices, despite Mr. Mello's, D.L. Tully's, and D.A. Morrissey's knowledge for more than 1 year that such evidence has been in the Commonwealth's possession, and that at least one of Mr. Carney's cellular phones had been extracted. So we know Mello was lying to the court. Mr. Mello has certified that his services as a special assistant district attorney incurred as of September 20th, 2023. DA Morrissey officially authorized Mr. Mello's engagement on September 26, 2023. Thus, DA Morrissey agreed and understood prior to September 29th that Mr. Mello was the proper official to handle investigations related to Mr. Carney's alleged intimidation of witnesses in the Reed case. On September 28th, 2023, Chris Albert, a witness in the Reed case and an alleged victim in the 2023 indictment, sought but was denied a protective order against Mr. Carney before Judge Daniel O'Malley of the Stoughton District Court. This application was heard and decided in a courtroom open to the public. Later that day, Mr. Carney published a blog about this matter. So Chris Albert goes to court trying to get a restraining order from Turtle Boy because guess what? Turtle Boy's reporting things about your family that might be bringing some family secrets to light that could potentially indict some people on conspiracy to cover up a crime, conspiracy to a homicide, maybe some charges along those lines. Um, so yeah, Chris Albert, he doesn't like Turtle Boy talking, so he goes to court, tries to get a restraining order, and this is what happens. So, and then Turtle Boy writes about it that evening. So they weren't happy about it, the McAlberts. That evening, Jennifer McCabe, another witness in the Reed case and an alleged victim in the 2023 indictment, complained in a text message to an unnamed individual. Quote, I know it's late, but I'm horrified that Chris didn't get it. And I am even more disgusted that for the second time, someone from the court leaked it right away to TB, meaning Turtle Boy. So on May 30th of 2023, Ms. McCabe unsuccessfully sought a protective order against Mr. Carney, also in the Stoughton court. The application was also decided in a courtroom open to the public. So both of these are public courtrooms, public court documents. He could have attended these if he wanted to. He could have been there. He could have gone to the courthouse and looked up your name and gotten information. Not that difficult. It's public record. But in this text, Jen McCabe is saying, I'm horrified. I know it's late because it's late when she texts him. But I am horrified that Chris didn't get it, meaning the restraining order. And I'm even more disgusted that for the second time, someone from the court leaked it right away, meaning the transcript or the audio or whatever he got from the court regarding the hearing on the restraining order. So, because he played it. I know he played the Chris Albert one. I don't know if he played the Jen McCabe one, but he might have gotten the transcript or something to that. I don't remember. But point is, after those hearings took place, public hearing took place, then he went and Turtle Boy got the transcript or audio recording or whatever it was from that hearing specifically so he could listen to it. It has to do with him. Why not? He has every right to listen to it. But they have a problem with that, of course. And where was I? Oh, come on. I can never find the footnotes. Where did I leave off? Somewhere down here, right? Oh, here. Okay. Sorry. Ms. McCabe's message was forwarded to D.A. Morrissey, who included it in an email he sent the following day to Stacey Fortes, the Chief Justice of the District Court, Thomas Ambrosino, the Massachusetts Trial Court Administrator, Philip McHugh, Deputy Court Administrator, and Judge O'Malley, First Justice of the Stoughton District Court, and Lynn Beeland, Norfolk County First Assistant District Attorney. D.A. Morrissey used a personal account, so he emailed all of these people. He used a personal email account to communicate with numerous high-ranking court officials, including the judge who denied Mr. Albert's application for a protective order about official business he described as a matter of grave concern. Someone in the Stoughton District Court shared an affidavit that was prepared by a witness in the Commonwealth versus Reed case with Mr. Carney. Okay, so let's tackle this footnote first. Email addresses used by employees of the Norfolk DA's office and in mass.gov. The email address used by DA Morrissey for his September 29, 2023 message ended in iCloud.com, which is associated with an individual's personal Apple account. So that's what he was using. Personal email, which is a big, big, big no-no. And it's supposed to be on public record. Well, first of all, he's not supposed to be having these communications, period. And that's why, because that's why it's supposed to be on public record using your public email that anybody can get and email you if they have a problem. Not keeping it all in the dark. All right, so without elaboration, DA Morrissey named court employee Michelle Littlefield as the leading suspect. So this Michelle Littlefield. That same day, Catherine Peter, an MSP source, we've talked about her, against Mr. Carney, tweeted that Mr. Carney would be arrested on October 10th, 2023. He was arrested on October 11th. So how did she know she was off by one day? How did she know that? Somebody from law enforcement is talking to her, or they are talking. They're exchanging information. She also was helping them kind of stake him out and watch his kids so that they could arrest him while his kids were getting on the bus, because that's the way to do it in America. Anyways, in an October 3rd, 2023 Facebook post, Ms. Peter publicly identified Ms. Little as the target of the unpublicized investigation, posted her picture, and announced that Ms. Littlefield had been suspended as part of the investigation. So not only did they wrongfully accuse this woman of doing something that wasn't even illegal, but they suspended her and publicly shamed her, outed her, whatever. But that's Kate Peter for you. He expressed concerns that the Reed case witnesses had lost faith in the courts and that the actions erode the trust. So this is the email from Michael Morrissey to all those judges and higher ups. He has concerns because the witnesses, Jen McCabe and Chris Albert, have lost faith in the courts, and the actions erode the trust and integrity between the courts and the public and the relationship with the DA's office. We are extremely concerned that the improperly disseminated court material unsolicited to a third party, which is continuing to cause harm and damage to a witness in an ongoing homicide prosecution, must be a violation of court policies or a potential violation of law. We also understand that Aidan Carney had also immediately requested copies of the FTR report that was made on 9/28/23. Again, there is no way that he would have or should have known that a hearing took place. Well, it's public. It's public record. You can find these things out. Maybe someone told him that something was happening, but so what? Because it's still public record, all of it. DA Morrissey concluded by demanding that these matters be resolved immediately and that he would await your advice. So he's telling these judges, resolve this immediately. Sounds like a threat to me. After Mr. Carney's October 11th, 2023 arrest, his cellular phones were seized and maintained by Tully. Transmissions from 7:53 a.m. on the day of Mr. Carney's arrest confirmed that MSP officials assigned to arrest Mr. Carney, including Tully, heard from KP it was the same thing yesterday, two older kids getting on around the same time, but it was 8:30. That was a quote. Somebody said over the whatever, like the radio waves, and it was in the recording. I'll repeat that. Someone heard from KP it was the same thing yesterday, two older kids getting on around the same time, but it was 8:30, meaning Kate Peter was watching Aiden from afar as he was guiding his kids onto the bus. That's a level of sickness. Mr. Carney was arrested at 8:34 a.m., 1 minute after his children boarded a school bus. Remarkably, it appears that Miss Peter participated in the MSP's apprehension of Mr. Carney by surveilling him at their behest. So you better be careful what you wish for. You want to mess around, you'll figure out real soon that it's not fun and games to be setting innocent people up for crimes and whatnot. So I'm going to just read 7. Sorry, so many footnotes here. Within 1 hour, Ms. Peters sent a childish and harassing direct message on Twitter/X to one of Ms. Reed's attorneys. Kate Peters sends this to David Yannetti. We know you're involved in Carney's little witness harassment game, and your text with him have already been making the rounds. Buckle up, Buttercup. That almost sounds like a threat to me. Detective Lieutenant Tully has testified that he viewed text messages between Mr. Carney and Ms. Reed's attorneys on Mr. Carney's cellular phone in October 23rd or 20 in October 2023. Sorry. And then she says, "Buckle up, Buttercup." Ms. Peters' baseless implication that Ms. Reed's attorneys engaged in witness intimidation is another example of her pattern of engaging in violations of witness intimidation herself. So there you go. On October 31st, 2023, Stoughton District Court Clerk Lauren Green presented Ms. Littlefield with evidence, quote unquote, evidence gathered during the investigation demanded by DA Morrissey. These materials included copies of DA Morrissey's September 29, 2023 email and several pages from a Cellbrite extraction report from one of the cellular phones seized from Mr. Carney on the 11th of October. Mr. Mello's misleading assertions about Mr. Carney's devices. On October 19, 2023, Mr. Mello emailed co-counsel Timothy Bradel that he did not know how far the MSP had progressed in any review of Mr. Carney's devices. A few hours later, after speaking with Detective Lieutenant Tully, Mr. Mello updated Mr. Bradel. Detective Lieutenant Tully is the only individual in possession of the electronics seized. So Mello wrote this to Bradel to have after it came out that Tully was the only one with the devices, or that he didn't know how far the search has gone, meaning like he implementing that like or implying that there was a search that began. So how far they got in the search, come on, you know they did an extraction. But by saying that, it's almost like, well, they could have started. I don't know. So a few hours later, after speaking with Detective Lieutenant Tully, Mr. Mello emails Bradel and says, Detective Tully is the only individual in possession of the electronics seized, and I can confirm that he will cease any further searches until this matter can be addressed by court. So he has started searching. He will cease any further searches. So he's already searched. This is the problem. This is why they're not handing it over. This is October 19th, 2023. This is right after he's arrested. They've already searched it. From October 20th to November 8th, 2023, Mr. Bradel asked Mr. Mello 3 times if Mr. Carney's phones had been imaged, which would have made it unnecessary for the Commonwealth to maintain possession of them. Basically, they can make a copy of all of the data in minutes, hand the phone back to the witness, the suspect, the individual, and they can still do their data extractions without the phone. So they asked if it had been imaged, which would have made it unnecessary for the Commonwealth to maintain possession. On November 16th, Mr. Mello reassured Mr. Bradel that Mr. Carney's devices had not been searched. I gave you my representation that we would not examine the contents of the electric devices without sufficient prior notice to you. Please know that we obtained search warrants this morning for the contents of said devices. So when is this? Defense has not been provided with these warrants or underlying affidavits. We demand immediate production of these documents. Hand it over, bub. Why do I lose my spot every time? 11, where are you? Okay. I have asked D.L. Tully, and he has agreed to refrain from executing said warrants. Your client's devices will not be examined prior to the court's ruling on your motions. They've already been examined, so you mean to say they won't be examined again. On November 28th, 2023, at a hearing in the Stoughton District Court, Mr. Mello couldn't have been any clearer in representing that Mr. Carney's devices had not been searched. There's a video of the presiding that he gives. Mr. Mello couldn't have been any clearer in representing that Mr. Carney's devices had not been searched. He says the state police and the investigators have not perused the material. It is in pristine form located on the defendant's devices. Pristine form. This is now November 28th. They took his devices October 11th. And they've already asked for them back multiple times. The court then asked Mr. Bradel if he had been advised by the government that they hadn't started the search and there's been no search done. Mr. Bradel indicated that it was his understanding that no search had occurred. Instead of clarifying the obvious misimpression that the court and Mr. Bradel believed Mr. Carney's devices had not been searched, Mr. Mello merely replied, "We would not investigate. We would honor our commitment to further not investigate." To further not investigate, meaning they already have started, until this matter is determined by the Superior Court. Mr. Mello further stated that if he provided the devices to the defense, Mr. Carney might delete data and thereby impair the integrity of a later extraction. In other words, Mr. Mello gave the court and defense the clear impression that Mr. Carney's phones had not been searched or imaged for extraction when he knew that the exact opposite was true. It strains credulity that Mr. Mello, who frequently discussed the investigation with D.L. Tully in October 2023, didn't know on November 28, 2023, that D.L. Tully had in fact searched Mr. Carney's devices and that at least one phone had been previously extracted. Mr. Mello's dubious representations are another topic that we intend to examine him and D.L. Tully's under oath in support. So, Mello and Tully, you're taking the stand. They intend to examine them both under oath in support of our pending motion to disqualify Mello under Rule 3.7a of the Massachusetts Rule of Criminal Procedure. Love this. Take them down. Mr. Mello's misleading representations and failure to disclose evidence he was obliged or obligated to provide to the defense several months ago likely violate a bunch of rules and the Massachusetts Rules of Professional Conduct. For more than 1 year, the Commonwealth has steadfastly refused to return Mr. Carney's devices. Even worse, Mr. Cosgrove, haven't disclosed to the defense any evidence contained therein. Instead, the Commonwealth has repeatedly maintained that Mr. Carney's devices have not been searched. The Commonwealth's obfuscation has harmed Mr. Carney professionally, and it has prejudiced him as a criminal defendant. He is entitled to data on his phone that is necessary for him to continue his journalism, and he has an absolute right to review evidence to which he is legally entitled. So not only does he have a right to that data because, well, one, it's his work product and data, and he deserves he deserves to get it back. But two, he's legally entitled to it because it's discovery. So they should have handed it over as discovery since they did an extraction of his phone without permission or a search warrant. Given irrefutable proof that Mr. Mello and D.L. Tully and almost certainly D.A. Morrissey have known that Mr. Carney's devices were searched and at least one extracted in October 2023, the Commonwealth's failure to disclose any evidence recovered from Mr. Carney's devices and any extraction reports from his cellular phones is indefensible, a clear violation of his due process rights to access material evidence and to fully prepare a defense. The defense believes that Mr. Carney is being prosecuted to stifle his First Amendment rights to report and opine publicly and loudly about alleged corruption and misconduct in the Reed case by the Commonwealth, MSP, and civilians who are now witnesses against him. We further allege that the MSP wanted to seize Mr. Carney's cellular phones to improperly access his sources of knowledge about the Reed case and to review any information he possessed regarding a federal investigation into their conduct during the Reed investigation and prosecution. Damn, Bederow. The long sentence, and you've said a lot, but you said it well. Yeah, so I don't even know where to begin on that. So Carney's saying you're doing this basically just to shut me up when I have a right to speak out publicly about the corruption that's going on in this case. And um, we further allege that MSP wanted to seize Carney's cellular phones basically to get their sources. So they want to shut him up and get his sources and see what information he knows about the federal investigation. Remember, Mike Morrissey tried to nudge the Attorney General to see if he would give him any information about the federal investigation, but he didn't. Accordingly, pursuant to Bradley, slow down, Heather. Accordingly, pursuant to Brady versus Maryland, Graham versus District Attorney for Hampton District, and Rule 14, we demand any information and evidence in your possession, custody, or control regarding the seizure, search, and extraction of Mr. Carney's devices, including but not limited to true, accurate, and complete copies of any data searched and/or observed, any extraction reports, search warrants, affidavits in support of search warrants, when the devices were searched and extracted, by whom, any reports, email documentation in any form describing the contents, searches, or extractions of the devices or communications between and among or to or from D.A. Morrissey, Mr. Mello, D.L. Tully, or anyone associated with the Norfolk DA's office or MSP, any of the individuals referenced in D.A. Morrissey's September 2019-2023 email, Ms. Littlefield, Ms. Green, any other employees of the Stoughton District Court, Jennifer McCabe, Chris Albert, and Ms. Peter. I mean, damn, Bederow. Everyone and their mother, we want it all. Every single piece of information where someone from the DA's office or the police could be contacting any of the witnesses or each other on private lines. We look forward to your prompt disclosure of the requested evidence and any other required Brady and Giglio disclosures that result from your discussions with DA Morrissey, Mr. Mello, DL Tully, or any other appropriate individuals regarding the issues we have raised about Mr. Kearney's cellular phones. And that is signed Mark Bederow. We've got a bunch of exhibits. I'm not going to go through them on here. We're going to go through them on, on here. And I just opened another window. Okay, I didn't need that. Sorry. All right, so we read through the Bederow letters. Let's have Turtle Boy explain and give us some context on everything. It began on September 28th, 2023, when Chris Albert walked into Stoughton District Court and attempted to obtain a harassment prevention order against me. 2 days after, I stood next to him at a select board meeting holding a sign that said Chris Albert, K-I-double-L'd, a man. It's pretty great. In his he says after David because there's some guy that calls it that in some meme somewhere and it's pretty funny, but I'm going to pronounce it affidavit correctly. All right, so in his affidavit, Chris Albert alleged that I caused him emotional harm, which made it hard for him to live like a normal person. And he posts some of the documents here from the affidavit in support of harassment order. He says, I believe the police have kept copies of said videos. What? Videos of Carney that have been published to followers and publicly available for viewing without being a subscriber. All of Turtle Boy's videos that Chris Albert thinks he's somehow threatening him in. I received a phone call, and this was the Yes Chicken Parm Charlie. I'm the award-winning journalist Aiden Carney calling you back, blah 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 blah. He went on like we've read through all of this in his charging documents for Turtle Boy. However, it seems like what they basically did was cut and paste Chris Albert's affidavit and made that into the charging documents because it's very similar. So he lists different quotes and things that he says on his show. We've gone through all of this. Like, I got bad news for you, Chris. I got really bad news. They are literally everywhere. Speaking of turtle riders, you guys should just stop going out in public. It's only going to get worse from here. Like he says that's a threat. So I don't think it's a threat, but nor is there any threat of violence in this. I'm not going to read through all of this, obviously. I'm just going to go over the things that Turtle Boy highlighted here in the underlines. Here it says, I was so proud to see turtle riders unafraid confronting evil like this in the flesh. Meaning, Turtle Boy or turtle riders confronting the McAlberts in public, because that's what that was referring to. Um, He was present. This is Chris again saying he was present outside of my business for over 1 hour in which he was harassing customers, interfering with traffic, and insulting drivers who were stopped outside my store. Well, that's definitely disingenuous of what really happened because stood out there peacefully protesting and did he say some nasty things maybe about about Albert? Sure, maybe because he's done some nasty things, and so has his other family member. So basically, it's the same things that were written in the indictment. This was all his filming the actions, holding signs. Um, yeah, just dumb stuff. He says he's feeling threatened, and the above listed incidents have caused me great pain and stress. My mental health is not great. I wake up every day thinking about this and go to bed with it on my mind. It's caused my business to suffer and strained my relationships. It's an ongoing battle every day to live my life like a normal person. It needs to stop. My right to live peacefully is being infringed as well as my family, friends, and extended family. What about Karen's right to live peacefully and not to be prosecuted and persecuted over and over again by Norfolk County? All right, so Turtle Boy goes on to say, notice the quotes from my YouTube show that Chris cited as harassment were the exact quotes that were used in his charging documents against him when I was charged with felony witness intimidation 13 days later. So 13 days after the restraining order for Chris's RO is denied in court. 13 days later, the same judge issues the witness intimidation charges on Turtle Boy. So this is a dry run for the witness intimidation charges, but it ended up in defeat when Judge Daniel O'Malley denied Chris the order, saying that my speech did not constitute true threats and thus was protected under the First Amendment. Clearly, Chris had been coached by the state police and the DA's office to emphasize that he felt emotional harm because they had already formulated a plan to exploit that vaguely worded statute in a way in which it would or could be used to arrest journalists and insulate elected officials like Chris Albert from legitimate criticism from citizens. Although this was not enough to pass the bar for harassment prevention order, it was enough to charge me with the much more serious felony witness intimidation. So it's not enough for a misdemeanor or whatever a harassment is. It's not enough for that, but it's totally enough for felony witness intimidation charges, 13 of them to be exact. Judge O'Malley also put stay away orders in place preventing me from contacting Chris Albert and the others despite the fact that he had denied such an order on First Amendment grounds just 13 days prior. Again, same language. He denied the restraining order. 13 days later, he approves the arrest warrant or whatever for Turtle Boy after these witness intimidation charges he sees. Since I have sources in every courthouse in the state, and Chris Albert is an extremely recognizable figure, multiple people reached out to me to let me know that he was in the courthouse trying to get an order on me on September 28th. These hearings are not private, and the affidavits filed with the court are publicly available to anyone who wants them. Anyone. I made a post announcing that I knew Chris was in the courthouse and would be writing about it later. So here is the Clarence Woods Emerson post. Dear Chris Albert, I know what you did today. Blog coming soon. And this was regarding he knew that Chris Albert went and tried to get a restraining order. Chris Albert applied for an order against me today in court and was denied, and his affidavit is the funniest thing I've ever read. Funnier than Jen McCabe's. All this because I peacefully protested at the Board of Selectmen meeting. After I obtained the publicly available affidavit, I published an article on it. This prompted Jennifer McCabe to immediately text message someone from the DA's office telling them that she was horrified that Chris didn't get the order, and even more disgusted that this public document was obtained by Turtle Boy. How dare you give it to Turtle Boy, a member of the public who, by every right, as a member of the public, has a right to the document? Instead of informing Jennifer McCabe that when you walk into a courthouse and go in front of a judge, you are doing so with the understanding that anything you say can be heard by the masses, Michael Morrissey himself immediately sprang into action in defense of the McAlbert Mafia feelings of the Mafia members of the McAlberts. He used his personal email account, iCloud, to contact the following state officials on their government email accounts. Stacey Fortes, Chief Justice of the Massachusetts District Court, Thomas Ambrosino, or however you say that, Administrator for the trial courts, Philip McHugh, Deputy Court Administrator, Stoughton District Court Judge Daniel O'Malley, Lynn Beeland, Michael Morrissey's second in command as ADA for Norfolk County's DA's office. In his September 29th email, he began by expressing his grave concern about the actions of a Stoughton District Court employee who he believed was a woman named Michelle Littlefield, accusing her of sending me Chris Albert's public affidavit. So even if this Michelle Littlefield had done this thing that they're claiming she did, it's not illegal, and it's definitely not fireable. It's not an offense to fire someone over or suspend them, but that's what they did. All right. They accused her of sending Turtle Boy Chris's affidavit. So here is the actual screenshot of Michael Morrissey's email to all of these people. And the subject says, Stoughton District Court issue. Dear Judge Fortes, I am writing to express my grave concern with actions taken by an individual employed at the Stoughton District in regard to an affidavit that was shared with a blogger writing about an online second-degree homicide case. They love to throw in the fact that he's a blogger, just a blogger. Like it's so demeaning to be a blogger. He's not real news. He's just a blogger. Drives me nuts. They throw that in there all the time. On September 28th, 2023, a witness in the Commonwealth versus Reed homicide case filed a request for an application for harassment prevention order, which was heard before Judge O'Malley. The application and affidavit were processed in the civil clerk department of Stoughton District Court and presented to a judge, which, after hearing, was denied. We were informed by the witness and other witnesses that shortly after the hearing that Aidan Carney, aka Turtle Boy, was provided a copy of the entire affidavit. There is no way that he would have been aware of the proceeding without an insider working in the courthouse. The leading individual who presents as a possible leak is Michelle Littlefield. How they got there, there's speculation as to how they got there, but it, um, she's not connected to Turtle Boy in any way. He says, I'd never spoken to her before and had never even heard her name. But even if she had sent this information to me, it wouldn't be illegal since the court hearings are public and so is the affidavit. The email contained a screenshot of a message sent by Jen McCabe referencing her failed attempt in obtaining the restraining order. And this is the I know it's late, but I'm horrified that Chris didn't get it, and I'm even more disgusted that for the second time, someone from the court leaked it right away to TB because this was something he was talking about on the show. He was talking about it on the show, so she was horrified. We looked at that already. All right, so Morrissey went on to bemoan how horrible it was that Jennifer McCabe, who the evidence shows participated in the taking of the life of Boston police officer John O'Keefe, and covering it up, had lost all confidence in the court of the Commonwealth. God forbid she loses confidence in the court when she doesn't care. She just wants it to work for her. She doesn't want her family to go down and herself. Morrissey, who is unconcerned about the public's confidence in the detectives he uses to investigate homicides and the public's trust in the DA's office as a result of the Karen Reed and Sandra Birchmore investigations, expressed his concern about the public's confidence and trust in his office as a result of a public document being released that embarrassed the McAlberts. Oh my gosh, we can't embarrass the McAlberts. That's illegal. How dare we? So it cuts off. Did it cut off above? We don't have the top part. It just says something something. Okay. It's clear from the postings that Stoughton Court is directly involved in this dissemination of information affecting our homicide prosecution. How is it affecting the prosecution? Because the truth is getting out? Yeah, the truth is that Karen didn't do it, so it's affecting your prosecution. If that's the case, that's the case, and you shouldn't be prosecuting her. From the comments from one of the witnesses, you can see that they have completely lost all confidence in the courts of the Commonwealth. Oh boy, that's just no good. I have to agree that the actions erode the trust and integrity between the courts and the public and the relationship with the district attorney's office. We are extremely concerned that the improperly disseminated court material unsolicited to a third party, which is continuing to cause harm and damage to witnesses in an ongoing homicide prosecution, must be a violation of court policies or a potential violation of law. We also understand that Aidan Carney had also immediately requested copies of the FTR record that was made on 9/28/23. Again, there is no way that he would have or should have known that that hearing took place. Stupid. Yeah, he can find out easily. It's public knowledge. I was going to say something and about something I read earlier. Now I don't remember what. Maybe it'll come out to me or come to me. So there are a number of concerns that we have about the possibility of having to file ongoing motions or other requests for warrants before the court that will affect the orderly and fair administration of justice. These actions are completely unacceptable and must be resolved immediately. So, as the DA, I am telling all of the judges to resolve this issue immediately. I understand that you have to do an investigation. And did I skip? No, sorry. Okay. I thought I skipped a line. My eyes are going bad. I understand that you have to do an investigation and that may take time, but you have also have to provide us with some evidence and assurance that you have taken action so we can safely continue to use the clerk's office of the Stoughton District Court. We have a number of delicate matters before them on a day-to-day basis. I await your advice. Michael Morrissey. I was going to say something about the dissemination or something. Oh, that he continues to cause harm and damage to the witnesses. Like that is he comes to a lot of conclusions that, Turtle Boy is bad and these witnesses are they need to be protected at all costs. It comes off that way to me. Morrissey claimed that the public document was improperly disseminated, even though by law the clerk's office would have to give it to me upon request, and said it harmed and that the dissemination of it harmed and damaged the witnesses somehow. It's unclear how anything besides Chris Albert's pride was damaged by the L he took in court that day. That was funny. Meatball Morrissey wrongly opined that it was a violation of the law for the clerk to do so and said that I should not have known that hearing took place. You shouldn't have known, despite the fact that Albert did this in front of a packed courthouse that was open to the public. Any one of the people in that courtroom, anyone could have told Turtle Boy. It doesn't have to be someone that works there. Morrissey lectured all these judges and court officials about how the actions of a whistleblower were unacceptable and told them that this must be resolved immediately. In doing so, he was telling them how to do their job, something that is not his job. He told them that you have to provide us with the same or with some evidence and assurance that you have taken action. So we need to know that you've done something about this. So you need to prove to us that he's not going to be a threat anymore. In doing so, he was directing Judge O'Malley to take action against someone for providing public court documents from his courtroom to Turtle Boy. And I would say prejudicing Judge O'Malley against Turtle Boy because saying that he's causing damage and all this to witnesses. Well, no, no, he's not. He's just reporting on the facts. And if that hurts their feelings, that hurts their feelings. So be it. This is extremely alarming for several reasons. Morrissey used a burner email address to conduct government business so that it wouldn't be available in public records requests. This means that he wanted to keep it a secret because he knew that it was inappropriate, unethical, and possibly illegal. He also spelled names wrong so that if for some reason this iCloud account, burner account did come about, like come to light, he spelled names wrong so no one would find it doing some kind of data search if you didn't search the incorrect spelling. So instead of Karen Reed, Read, he spelled it Reed, and he probably did that on purpose so it didn't come up if somebody did a FOIA request of his iPhone, his iCloud account. By directly communicating with the judge in my case, this constituted an ex parte hearing which violates my civil rights. He has, first of all, DAs don't have any right to tell judges how to do their jobs, nor who to prosecute, or, I mean, yes, sorry, I take that back. They do tell the judges who to prosecute, but they don't tell the judges how to do their job and how to run their courtroom. And when, you know, certain motions or uh, things come their way, they're supposed to use their discretion and based on the law as they understand it. But in this case, Morrissey is saying, I want you to do what I want you to do, which is highly unethical, illegal, big misconduct, big, huge. I think Morrissey, Mello, and maybe even Lolly might be getting disbarred in sometime in the future, possibly. Judge O'Malley denied the order against me on the 28th, and he got this email on the 29th demanding that he do something, and then instituted an order against me 12 days later without any evidence, any new evidence against him that was presented in court. It seems as if he was pressured and threatened to take Turtle Boy down, take him out, make him guilty. We cannot see any of the responses from these government officials. So that's why an extraction needs to be a FOIA request. I'm sorry, needs to be done, and somebody needs to get Morrissey's iCloud account information. So that makes Morrissey a witness, does it not? Especially too because Jen McCabe was texting Morrissey. That makes Morrissey also very biased, unethical, um, prosecuting Reed and Turtle Boy for his own reasons. We cannot see any of the responses from the government officials, so extraction is important. Or FOIA, sorry. Why did Morrissey accuse Michelle Littlefield on September 29th? That's a good question. What most likely happened is that he was alerted by Jennifer McCabe, either directly or indirectly, that someone in the clerk's office sent me the affidavit. He would have no idea who, so he most likely gave the McAlberts a list of all the clerks' names, who then sent the list to people like Kate Peter, who ran those names for the in the Justice for John O'Keefe pages and the Kieran Reed Facebook page until they found someone who was a member. That's what he thinks happened. 4 days later, on October 3rd, Kate Peter used her Mass Hole Report Facebook and Twitter accounts to dox the clerk Morrissey, accused of being the person who sent the public documents to Turtle Boy. She posted her name and picture accusing her of leaking personal information and said that she was perp walked out of the court and suspended from her job. This poor woman didn't do anything wrong, and she was suspended from her job for nothing. No reason. She called the woman a effing scumbag, told her that she worked for me, Kate Peter, is employed and does not pay taxes, and said that trust and believe more consequences would be coming. She also mentioned Avon dispatcher Janelle Webb, who was not charged with any crimes at the time and whose identity had not been made public. So Janelle is the dispatcher who got, I believe, fired, and they are trying to get charges on her too for witness intimidation and conspiring and whatnot, whatever, because she looked up Jen McCabe's license plate, which happened to be because Jen McCabe's car was in front of Michael Proctor's home, a witness in front of the lead detective's house. And somebody took a picture of her car. They got the license plate. Janelle ran the plate and confirmed that it was registered to a Matthew McCabe. So there you have it. And that was never even disclosed in public. So how she got that person's name, she obviously was getting information fed to her from the McAlberts or the Norfolk County DA's office. This was Masshole Reports tweet or whatever Facebook page, I don't know. This lovely lady is redacted. If you're down at Stoughton District Court, you can rest easy. Your personal information is safe for the time being, as she was perp walked out today and put on suspension tongue. Let me back up. She was perp walked out today and put on suspension pending an internal investigation. What is it that Karens like to say? You work for me? Well, redacted, you effing scumbag, you work for us, and your decision to share sensitive information entrusted to you through the court to further harass and stalk a civilian really caught up quick. Trust and believe it's going to follow you around too. You will be getting more attention soon, as will our new friend Janelle. I hope both of your careers were worth it. And she shared a picture. This is the psychotic way that this other side thinks. It's sickening, really. So this is more direct evidence that Ms. Peter works directly with the DA's office and the state police as their mouthpiece on social media. She knew about the clerk being suspended within minutes of it happening. She knew about Janelle Webb before she had been fired or linked to the conspiracy charges that I would be arraigned for 8 days. So she knew all this stuff. How did she know this stuff when it hadn't been public yet? She also stated on September 29th, the day Morrissey wrote the email from his burner account, that I would be arrested on October 10th. Turns out, she was only off by one day. It says, still waiting on that subpoena any day now, right? Someone said in response to Masshole Mafia's text or tweet that says, people often ask us why we bother to archive Dr. Turtleboy. It's times like this when he accidentally shares illegal recordings and takes them down real quick. Sorry, R word, but it's been something. Something. Okay. It's been saved, I'm assuming. So this person said, still waiting a subpoena any day now. And then Masshole Mafia responded, October 10th, he knows the deal. Today is October 10th. You said he'd be getting a subpoena today. Was that another lie? And then she says, sorry, it was actually today, the 11th. Arrested, baby. She's happy. He's arrested. There are dozens of other things she has posted on social media that prove she is in direct communication with the DA's office. For instance, she knew on April 3rd that Michael Proctor was under internal affairs investigation for his text messages saying horrible things about Karen Reed. Another tweet of Masshole Mafia. Sick of hearing today that Michael Proctor is under IA investigation for lying to the grand jury. That is patently false. He is under IA investigation for calling Karen Reed the C word, making fun of her colitis, and making jokes about looking for nudes in her phone. If you think that's why there was a grand jury or that's why he's being investigated, you're way off. Those things he probably would have gotten away with, no biggie, if they hadn't, been publicly aired on the television. But he's definitely in trouble for some kind of misconduct, possibly tail light planting. That's what I would guess. That's what I would guess. It's not for the bad words he called Karen, and it's not for probably looking for nudes in her phone. Yeah, that would probably get someone fired in a normal situation. But with the police, they don't fire one another. They just sweep it under the rug, I guess. So take from that what you will, but if you people are going to smear the guy, at least be factual and honest. Kate Peters says. This is before any of this information had come out in court. Clearly, the DA's office is leaking information to her while publicly crying about Karen Reed's team leaking information to me. They are using this woman to harass and dox government employees who act as whistleblowers to inform the public about government corruption, which she shouldn't have, she didn't even do anything wrong, yet, she would have been a whistleblower if she had sent the document to Turtleboy. Even more shockingly, state police radio transmissions from the morning I was arrested show that Kate Peter was at my house doing surveillance on October 10th in order to inform the state police with time that my children got on the bus. What time my children got on the bus. So there's an audio recording. Should we play it? Let's play it. Hold on. See if I can get to it. Here we go.
Supposed to be around 8:30, but Kevin, if you want to try to take a drive by past that bus.
Yep, I'm right in front of the bus. I don't see two kids getting on the bus at that street.
We'll take a look. Without really hearing you guys, but
This is just audio. This is the dispatch line where they're talking about, arresting Turtle Boy, and they're talking about all the buses that they're seeing that morning. There was another bus that comes before the bus that takes Turtle Boy's kids, so they thought they went to the wrong bus and thought that was the one. So now they're waiting for the correct bus.
Kevin, can you go again? Two kids on the bus or getting off the bus?
There were two older kids that were getting on the bus. I'm sure there's another one coming through.
Received.
Sir, from KP, it was the same thing yesterday. Two older kids got on around the same time as now, but it was definitely 8:30.
You hear that? I'll repeat what he said. Heard from KP, it was the same thing yesterday. Two older kids got on around the same time as now, but it was definitely 8:30. So you can hear him say it was KP.
Received.
Heard from KP. KP could very likely be Kate Peters.
Sir, from KP, it was the same thing yesterday. Two older kids got on around the same time as now, but it was definitely 8:30.
So KP was out there surveilling Turtle Boy to find out when his kids got on the bus. That's sick. That's just sick. State Police, under the command of John Fanning, they call him Johnny in those transmissions, observed a middle school bus on my street pick up two kids at 7:53 a.m. They were unsure if they were my children, so Trooper Kevin contacted KP, who assured them that she witnessed my children get on their bus at 8:30 the previous day. Does it go on? Does she talk to them?
Received. Cat. R9.
Negative into the circle across the street.
Okay, received. Still standing by for the yellow target to go by.
Received. I just had Alexis pass me. I'm just confirming it's not him. That was not our target.
All units, bus 33, coming off of Wood onto Boulder.
Making a stop on Boulder.
no, we'll follow behind you in a minute. Okay, these houses behind the bus. On Mason.
So I'm like 100 yards behind you.
Okay, the bus went right by, didn't stop at Piccadilly, it's still moving.
Kind of funny how they can figure out what bus it is. I don't know. I don't think they call her on here. That's why I was trying to find out if she gets on the line or if somebody asks her.
Yeah, we're doing the slow roll because it's going to take, we give us a little time. As soon as he puts the kids on, we'll jump on him.
Received. Everyone stand by until I give word. Everyone can stand by until transport arrives.
Going up now.
All units, once transport moves out, we can pull into the driveway, and we can.
Isn't that scary? That these guys can just sit there and be doing this right behind your back, and you don't know, and any minute they're going to pop out and arrest you. It's terrifying. They were unsure. Okay, I read that. Why was Morrissey involving himself in the witness intimidation case against me on September 29th? He hired Ken Mello on September 20th specifically to avoid the conflict. So here's a contract where Ken Mello was hired and he was brought on September 20th. An internal email from a records request shows that there was a meeting on September 26th in which they all agreed Mello was in charge of the witness intimidation case. So we've got Deborah Leahy. This is from Deborah Leahy. It's to Lynn Beeland, Catherine Regan, Kathleen Barnett. These are all mass.gov people. Special Assistant District Attorney. Hi, Lynn. Regarding the meeting with you and the District Attorney today, our office is going to be hiring Attorney Kenneth S. Mello as the Special Assistant District Attorney for the Norfolk District Attorney's Office. His rate is $400 per hour. I will put the maximum obligation amount of $30,000. Please let me know if you think this amount should be adjusted. We know that there was at some point in time, months ago, there was a record that came out that he was being paid over or he has already been paid over $80,000 for litigating this case, and he's been sick for half of it. Also, we can adjust or increase moving forward as well. Please approve so I can prepare the electronic contract to email to Attorney Mello. He was billed the taxpayers for more, or has billed the taxpayers for more than $80K already for his services. And there's a breakdown of his hourly rate. So, why was Morrissey involving himself on September 29th in a case in which his office had been recused? When Michelle Littlefield was put on leave on October 3rd, they didn't have any solid proof that she had contacted me because she never had. However, on October 11th, when state police seized my phone, they immediately began going through it, looking for information from whistleblowers about her to see if anyone had given me information on the federal investigation into MSP and the DA's office. Despite claiming that they have never gone through my phones, Stoughton District Court Clerk Lauren Green confronted Littlefield with a Cellbrite extraction from my phone showing a conversation with a friend of Michelle who sent me the Chris Albert and Jennifer McCabe's affidavits. So here is the extraction report. It says you can now message and call each other and see info like active status and when you've read messages. Yeah. Did you get a copy of the affidavit? And then there's 2 attachments, it looks like. Oh, wow. How'd you get this? I believe the proper term is sources, LOL. I have some friends that work over there that are turtle writers, so it seems like it's an intermediary. Unless he's talking to. Yeah, this on your right is going to be Turtle Boy, on your left is his source. But they intentionally omitted the first message he sent from the extraction in which he told me that a reporter from Boston 25 was also in the courtroom. A little turtle told me that Jen McCabe was in Stoughton Court today to file a restraining order against you. It was denied, but you may want to call tomorrow about getting a copy of the affidavit. Bob Ward from Fox 25 was there for a separate matter, but stayed for the judge's decision when he heard about it. And Turtle Boy says, LOL, you heard about that? So he already knew, apparently, that I just messed up my hair, didn't I? No, it's okay. he already knew apparently that this hearing was taking place. He might have already been tipped off. The DA's office intentionally left this part out because it would show that other media witnessed Jennifer McCabe trying to get an order against me. Therefore, it would be perfectly normal for me to find this information out on my own. They want to create the false impression that these orders take place in empty, secretive courtrooms that the public isn't allowed to know about. Littlefield was afraid to tell me this information for 11 months because she lives in fear of the state police and the DA's office. The woman who was suspended, and I assume probably fired eventually, or she left on her own because she probably was scared that the DA's office would do something to ruin her life, because it seems like that's what they don't care. When she showed me these documents a month ago, I was in shock, as the Commonwealth and police have repeatedly insisted that they have not gone through my phone. So this Littlefield had copies. I had an extraction of his phone. Those pieces that we just read through, the communications that we read through. She had a stack of his extraction from his phone, communications from his phone. And the only way she could have done that is if it was handed to her from Norfolk County, because they did a phone extraction. And that is what happened. Um, 11 months. When she showed me these documents a month ago, I was in shock, as the Commonwealth and police have repeatedly insisted that they have not gone through my phone. Yet here was this woman I never met holding a printout of my phone communications, which they used to punish her for being a whistleblower. Ken Mello repeatedly stated in open court on November 28th and in several email communications with attorney Timothy Bradel that the police have not searched my devices. In fact, he said they were in pristine condition and had not been perused by investigators. He lied in order to oppose a motion to give me my phones back, because he knows that if I have my phones, I'd be able to defend myself better, since all the crimes I'm accused of committing happened before they took my phones. If they had admitted to downloading my entire phone, which they clearly have done, then there would be no reason not to return my devices. Brian Walsh got his phone back in less than 24 hours, despite the fact that police knew he took his wife's life and dismembered her. Since then, Robert Cosgrove has repeated the lies several times in court, including at the July 11th hearing, in which there was a motion for the government to return my phones. Additionally, at a March 27th grand hearing convened by Mello, in which the only witness was Lieutenant Tully, he admitted on the stand that he had gone through my messages and read communications between me and Karen Reed's attorneys, which is obviously privileged information, and he never should have done that. Well, I guess they don't represent him, but still, as a journalist, as a private citizen, they should never have gone through his phones. They didn't have an affidavit or a warrant to go through his phones. Mello was aware of this by repeatedly denying any such thing that had ever happened in court and in emails with my attorney. So he's constantly denying. Brian Tully had access to my phone at 9:15 on October 11th. At 10:15, Kate Peter sent this threatening message to David Yannetti, telling him that, quote, we knew that he had texted Aiden Carney, meaning David had texted Aiden. She ended with the threatening and ominous buckle up, Buttercup. We read that. We know you're involved in Aiden Carney's little witness intimidation game, and your texts with him have been making the rounds. Buckle up. So within an hour, less than an hour, Kate Peter had access to things in Turtle Boy's phone. How she would have access to anything in his phone is beyond me, because she shouldn't. unless she's working with the Norfolk District Attorney's Office, which I think she is. She later tried to cover for herself by claiming that I had sent other people screenshots of my text messages with Yannetti, but the download of my phone will show that this is also a lie. This is another X post from Masshole Mafia. Dear Turtle Boy and David Yannetti, it has come to my attention that you two morons think the police were leaking Aiden's texts. No, Aiden shared texts between himself and David Yannetti in a group chat. This is the hackening 2022 all over again. LOL. Real funny. I've gotten nothing from the police, but you know who will? The jury. Have a nice day. And then she says, in fact, I can post them if you'd like. You'd think after all these years, Dr. Turtle Boy would smarten up and shut the F up in group chats. But no, here we are. It's effing Groundhog Day. Everyone, look at me. I need your affirmation at 6 a.m. as I try to climb Aiden's coattails for a second time. And that's the end of that. So, as you can see, this Kate Peter has a serious issue and she is obsessed with Turtle Boy. Anything related to Turtle Boy, even peripherally related to Turtle Boy, she is obsessed. And the Norfolk District Attorney's Office and law enforcement have used that to their advantage to get her to do illegal things for them. I mean, I'm just not going to mince words. I'm going to say that right out loud. She is committing more witness intimidation. She has actual witness intimidation charges on her and restraining orders on her for her behavior, for what she's done to other people, including Aiden. Aiden has a restraining order on her too. So, I mean, there's that. She's not well. She's not stable. And I don't like to talk about people, but seriously, she's not. I don't want to get into all the drama, but you can tell by the things she posts, the things she does, that she's obsessed with Aiden and just really obsessively goes after him on X and wherever she can. And like I said, they've joined forces, Norfolk District Attorney, the law enforcement, and Kate Peter. But things are starting to turn around. We're seeing Tully getting reassigned. We're seeing discipline. We're seeing certain instances of misconduct being reported now. So we are finally, I think, starting to turn that corner, even though we're still stuck with Cannone, which is just like, oh, knife to my gut. I can't with her. But we will move on. We will endure. We will get through it. And Karen will succeed. She will get out of this successfully, and so will Turtle Boy, and they will come out of this rich and famous because they have every right to the county's money now, the state's money for what they've done to them. All of the fake charges and the false claims from attorneys in court. I'm sick of it. They're sick of it. Karen's sick of it. And everybody's starting to fight back now. I really think the Norfolk District Attorney's Office did not know what they were getting into when they pushed so hard for this trial, because now it is so public, it's so out there, it is worldwide news, and everybody wants to know what's going to happen. And they all want to see, well, not everybody, but the majority of people want to see Karen acquitted because that is the right thing to do, and that is one step closer to justice for John O'Keefe. The next step would be putting away Brian Albert, Chris Albert, Colin Albert, any of the Alberts that were there that night that had something to do with John's death. Definitely Jennifer McCabe. Ooh, I want her so bad to go to prison just because, like, I don't wish bad things on people, but when I see corruption and evil and just rotten to the core, when I see that, I want our criminal justice system and society to clean that up. And once that happens, then we will finally get justice for John O'Keefe. And I will leave it on that note. Thank you guys so much for tuning in and watching and finding out what's going on. I know I'm a little late on the Bederow letters, but I wanted to get them out better late than never and give you the whole story. So hopefully you guys like that. And I will see you guys in the next one. Take care. Thanks. Bye now.